Good morning and welcome. We're pleased to have you with us today. We have 3 cases on the morning docket, which we will hear in the order in which they appear. Each side has a total of 15 minutes, and that applies whether there's one or multiple attorneys arguing for the appellants or appellees. So if you are sharing time, you'll have to divide it up. When the appellants come to the podium, you may reserve up to 5 minutes for rebuttal, so please, after you've introduced yourself, let us know how many minutes to reserve, and we will program the clock accordingly. Are there any announcements? Hearing none, please call the first case.
Robert Madden et al. Versus Metropolitan Board of Fire and Building Code Appeals of the Metropolitan Government of Nashville and Davidson County, Tennessee.
Good morning.
Good morning, Your Honor. Brianne Hadaway for the Metropolitan Board of Fire and Building Code Appeals. I'd like to reserve 3 minutes of time for rebuttal, please.
Very good.
We're here for the court's review of the decision of Administrative Board to deny a variance request. Because the board properly applied the variance ordinance and their decision was supported by sufficient and material evidence, this court should find that the lower court erred, reverse its decision, and affirm the decision of the board. For some factual background here, appellees purchased undeveloped land in Davidson County. They applied for a building permit, which was ultimately denied because the fire marshal determined that the nearest fire hydrant was 2,676 feet away. The code required it to be within 500 feet.
Would the code have required this fire hydrant to be within 500 feet for any sort of structure that was constructed in this particular lot?
Yes, Your Honor.
Okay.
They learned that actually during their argument that no change in structure type would alter the requirement.
And this was zoned industrial?
Correct, Your Honor. Appellee's fire suppression plan also did not comply with the fire code. It was an alternative fire suppression plan. They applied to the board for a variance under Metro Code 2.80.080, which I will refer to as the variance ordinance for simplicity. The board heard that the appellees proposed a 20,000-gallon above-ground water storage tank and a building-wide dry chemical suppressant system in lieu of being located within 500 feet of a fire hydrant. Replacing a fire hydrant, the fire marshal's office determined would require a 180,000-gallon tank for this type of building, which is 9 times bigger than what appellees proposed. And that proposed dry chemical system was also not acceptable for building-wide use. It was more of a specific purpose extinguishing system, such as for a paint booth. After the board properly denied appellee's variance request, the appellees filed for writ of certiorari in the trial court, and the lower court granted the writ and found the board misapplied the law in making their decision and remanded. Metro appealed. The trial court erred by substituting its judgment for that of the appellant board in finding that the appellant board misapplied the variance ordinance for 3 reasons. First, the board understood that they were considering a variance request and not an appeal. Second, the board explicitly opined the appellee's request did not satisfy 2 of the 3 required elements of the variance ordinance. And third, the board was not required to make findings of fact and conclusions of law. On that first point, contrary to the lower court's findings, the board did understand it was considering a variance request and not an appeal. The transcript evidences this. When he called the case, Chairman McCoy asked participants to, quote, explain to us your hardship and what alternative means of protection is proposed in lieu of literal code compliance. He read the applicable fire code, detailed the request, and detailed what would be necessary to have in order to not have a fire hydrant there, which was the 180,000-gallon tank. Now, unless there are other questions, we'll stand on our briefing for the remainder of our argument concerning whether they understood they were considering a variance.
What about the argument made by the appellee here about Metro's responsibility in the Urban Services District to provide fire service for these types of properties? You know, it seems like to me that the effect of this circumstance is sort of shift that obligation to property owners if there's no structure at all that can be constructed that doesn't have a fire hydrant within 500 feet. So, you know, does that not play into the variance analysis at all here?
It does not, Your Honor. Actually, there is an ordinance that requires that any any fire hydrant or water main that's run to an undeveloped property for a private property owner, no Metro funds shall be used for that. That is an ordinance that comes into play here as well.
But at some point, as the area develops, Metro will have to put in these fire hydrants.
Metro will not. It would have to be the private property owner. They then deed them over to Metro, and that's when Metro provides water service.
So you're saying that Metro doesn't put in new fire hydrants
Not in,
at its own expense?
no, Your Honor.
So really the promise of fire service is a promise that I guess the fire trucks will go there, but
Well-
not necessarily that there will be access to a hydrant.
Well, that's why the denial has happened. The hydrant has to be there. It's the responsibility of the property owner to extend that water main. That is codified in our code, and to basically put it there and deed it over to the city. At that point, we provide that fire service, we provide that water service, but it was never intended to be for free. It was never intended to be something that was done just for everybody as gratis. Now, when Chairman McCoy called the participants to the board's attention here, he asked them to explain to us their hardship and what alternative means of protection is proposed in lieu of literal code compliance. He read the applicable fire code, he detailed their request. It is very clear from the record that the board understood they were considering a variance and not an appeal. So for the second reason the board did not misapply the variance ordinance, the board members opined that appellee's request did not fulfill 2 of the 3 elements of Metro Code 2.80.080. Those 3 elements are all joined by the word "and," making each one of them mandatory. And they are whether strict application would result in manifest injustice, and number 2, whether strict application was contrary to the spirit and purpose or the public interest, and number 3, whether interpretation of the fire marshal's office should be varied. They first opined that strict application was not contrary to the spirit and purpose. The spirit and purpose of the fire code is defined in the 2012 International Fire Code, which Metro adopted as its fire code, section 101.3, as establishing the minimum, and I want to stress that word, minimum requirements for life safety, property protection, and safety for first responders during a fire-related emergency. Now, the board knew from the reading at the beginning that what appellees were proposing was 1/9 of the required capacity. That's only 11.1% of the water required to meet the fire flow rate for this building. I believe my calculations said it would allow them to fight a fire for approximately 12 minutes. The board learned that the dry chemical system couldn't be upgraded for building-wide use. The board also learned that no change in construction type could obviate the need for a fire hydrant, as we discussed earlier. And then when appellees argued that, hey, nobody's gonna be in here at night, and if this spreads, it's only gonna spread to the land next to Briley Parkway, might also potentially spread to the Nashville landfill, the board stated they're worried about the people in the buildings, which is why they were there. Another board member doubled down and stated their plan was, and this is a quote, problematic because their responsibility was the safety of people and buildings. Now, all these statements indicate that the board held the opinion that strict enforcement was not at all contrary to the spirit and purpose of the code, and that's that life safety, property protection, and safety of first responders.
Well, hearing your argument, I'm sensing that there's no justification under any scenario for a variance. When is a landowner entitled to a variance? What factors must exist?
The variances that have been described to me by the fire marshal's office would be situations in which a person is very close to meeting the requirement, and then they put in, say, an NFPA mandated sprinkler system that would then allow the fire department to slightly lower the fire flow rate. There are situations that preserve the requirements under the board, but allow them to operate slightly outside of the parameters. They're not talking about an 11.1% difference. We're talking about the difference probably between 95% and 100%.
Are the criteria for a variance in this record?
Yes, Your Honor. It's section 2.080.080.
So that will tell us under what circumstances a property owner might be entitled to a variance.
I believe so, Your Honor, yes.
Okay. All right. Now, I've read Judge Briley's order and a transcript of the hearing, and I'm trying to find where the board members expressed a view that the enforcement would be a manifest injustice and would be contrary to the spirit and purpose of this chapter, or that they considered, I should say, that they considered that circumstance, and I don't find it.
So, Your Honor, the board, like I said, there's 3 required elements, all 3 of which need to be met. Even if you find that one of them is missing, they can deny that variance because they're all mandatory.
So what you're telling me, it doesn't matter if the board didn't know what they were doing?
No, Your Honor, the board
Okay.
certainly knew what they were doing.
Then answer my question. Where in this record am I going to find an expression by any of the board members that they considered whether the strict enforcement would be a manifest injustice and would be contrary to the spirit and purpose of the chapter?
So my last point was that they found that it was not contrary to the spirit and purpose of the chapter. The way that the lower court wrote it was actually incorrect. The way it reads is strict application results in manifest injustice and strict application is contrary to the spirit and purpose. So not both at one time. So the board did not make a specific finding as to the manifest injustice, but they made opinions as to the other 2.
Which 2?
The second one would be that it was contrary to the spirit and purpose, and the third one being whether the interpretation of the fire marshal's office should be varied.
Okay, the last I agree with, but the first, you're saying a board member expressed that?
Yes, Your Honor. When the board members stated their plan was problematic because their responsibility was the safety and people of the buildings. Because that is the intent, the spirit, and the purpose of the code is life safety, property protection, and the safety of first responders in the event of a fire-related emergency. They also stated that they were worried about the people in the buildings, which is why they were there, which is why it was an unacceptable risk that the only place it could spread to was the land along Briley Parkway or the landfill. Now, the board also was not required to make findings of fact and conclusions of law, and that dovetails exactly into what you just asked, Your Honor. There's no requirement to use any magic words. There's no requirement in the ordinance to say manifest injustice or spirit and purpose. In fact, in Moore versus Metro Board of Zoning Appeals, this court found that as helpful as findings of fact might be in an administrative proceeding, administrative bodies are not required to make specific findings of fact unless a statute or ordinance requires them. Finally, the board's decision to deny appellee's variance request was based on sufficient material evidence that the nearest fire hydrant was 2,676 feet away, that their proposed alternative fire suppression plan was insufficient to meet the requirements or would be equivalent even to the requirements of the 2012 IFC, with a proposed tank of only 11.1% of required capacity and a dry chemical system that's not appropriate for building-wide use. Their sole justification here was pecuniary harm, and this court has repeatedly held that pecuniary harm or self-imposed hardship alone is insufficient to justify a variance. See, I'm running out of time. In closing, because the board properly applied the variance ordinance and their decision was supported by sufficient material evidence, this court should find the trial court erred and reverse its decision. Thank you.
Thank you.
Good morning, Your Honors. I'm
Good.
Nick Leonardo, the Nashville Bar, here on behalf of the appellees, the Maddens, and this really is a perfect storm of facts that have landed us here in court today. As Judge McBrayer noted and asked some questions, and I think the facts are very important here. These are average folks that have a collision repair business. They bought some property out there off Briley Parkway by the landfill, and there's not a whole lot of development been out there. But what is so very important is that this property is in the Urban Services District, which is completely different from the General Services District because they pay a higher tax rate, okay? And why are they paying the higher tax rate? Because under the charter, section 1.05, it says that Metro shall provide increased fire protection. And where this, in the record, it's kind of interesting to see, and I'm sure that Metro certainly would, if they had to do over again, they would have done it differently. But this tract is the last tract in the Urban Services District. It's bordered on one side by Briley Parkway, and then it's over by the landfill. Now, the Maddens, the mom and pop business, they to get a site plan approved. They pay for all these Metro permits. They actually cut trees and pay the urban forester. And they're about $70,000 in when they find out, when they try to get a building permit, oh, wait, you have to be 500 feet from a fire hydrant.
Well, that's not Metro's fault that they spent all that money without finding out about the fire protection.
Well, in a sense, and you're correct, Judge, but in a sense of fundamental fairness, you would think that would be something that was told on the front side before you're paying for trees and the like. But nonetheless.
Well, everybody's presumed to know the law and to try and figure these things out beforehand, aren't they?
Yeah, I mean, to some degree, I mean, you're right. I mean, you're absolutely correct. And so, I mean, that would be the negligence, I guess, or comparative fault, or whatever you want to say on behalf of the applicants. But nonetheless, the closest fire hydrants on Ashland City Highway, which is 2,600 feet away from the property. And the estimates were going to be $280,000 for this, to run this fire hydrant, plus the additional cost of a sprinkler system, which would be about $60,000, and a diesel pump in which to pump it. So they proposed alternate fire suppression plans. And so after they hit a brick wall and they said, there's nothing else we can do for you here, you need to go to the Board of Fire and Zoning Appeals. And that's exactly what they did. And Rule 9 allows a variance when strict enforcement will do a manifest injustice. And it's important to note that the only thing that they fell back on in this hearing was that they asked Mr. Allman, who's the fire marshal, they said, does this comply with the fire code? He says it does not. And the situation is that whether the building is 0 square feet, or 12,700 square feet, it's the same flow rate. And the fire code does not make an exception if you're building in Jolton, or you're building in the Gulch, or if you're building next door to this building. And it doesn't matter how big it is, 0 to 12,700. So that's exactly why the board is here, to determine, is there alternate fire suppression plans? Is there something that could be done in lieu of running this fire hydrant? And the record.
So you're saying, excuse me, I'm sorry, you're saying the tank that they proposed is sufficient?
No, sir. No, sir. I'm not
Okay.
saying that it's sufficient at all. I'm saying that the 2012 fire code, of which Metro is currently operating off of, makes no difference on the location and makes no difference on square footage between 0 to 12,700. And that's in the record. And that's the Appendix B that was contained in there. So that's why the board is there, to determine factually through the applicant, through the hearing, if this is entitled to a variance. And the board, and we even talked about in front of the board, that the applicants weren't asking Metro to just outright pay for anything. There was even discussions of doing what's called a participation agreement in Metro, where both parties pay a little bit. The appellant is correct that the cost to run that fire line or that water line from the fire hydrant 500 feet away to the property, that would be bore by the applicant. But to run, I mean, and we just learned, federal judge just recently said about the sidewalk case that it's unconstitutional to force citizens to pay for something that Metro is ultimately going to own. So they've done everything they possibly could to work with Metro to try to reach some middle ground. Now,
is there a standard, or are there factors that the board should consider and/or a reviewing court should consider when determining whether to allow a variance?
you're absolutely right, Judge Clement, and you already talked about those. And those are, one is the board's opinion that strict enforcement will result in manifest injustice, number one. That was never mentioned in the record, as your honors already pointed out. Number two is the board's opinion that strict enforcement would be contrary to the spirit and purpose of the fire code or public interest. And three, is it the board's opinion that the interpretation of the director of the codes administration and or Metro Fire Marshal should be modified?
But your argument seems to be that the trial judge didn't quite get it right here, that the trial judge said, well, what the board did in this case was really treat this as an appeal versus a request for a variance. And what you're saying is, no, they treated a request for variance, they just didn't do fully their job. Is that your argument?
The argument is that it was treated as a variance and they didn't do their job. You're correct.
And you're saying implicit in the variance analysis is is the board has got to tick off each element.
Or they have to consider, some of it, that's what they're there for. There has to be something in the record showing that they considered those factors.
But what about the counter to that, which is, well, this is in the conjunctive, and so if there's a failure of one, it really doesn't matter if there's a failure of the others, because if you've got a failure, or the existence of the others, because if you got a failure of one, you don't get the variance.
Well, the whole reason that I would say that if you look at those three factors, the spirit and purpose of the fire code and the public interest, I'm not going to concede that that was really talked about, because really all that was discussed was with the fire marshal. They asked him, and the board member says, you know what it takes to fight fires. I mean, as noted by the trial court's order, one board member, the considerations that were discussed, one board member said that they were fearful that they would be setting a precedent for future neighbors. That's inappropriate. Another board member said that the fire department must determine what it needs to fight a fire. And another one says that I can't approve it because the fire department knows what they need to do there. But most importantly, the motion that was made to deny this was made by an unidentified male. And it says that, I hate your situation, I'm sorry you're there, but it's a property that doesn't appear to be ready for development at this time. And as Judge McBrayer pointed out, this is industrially zoned property in the urban services district, of which they're paying a higher tax rate. And so I would submit that the record is devoid of any considerations of Article 9 under their rules as to, should a variance be granted? Is this some sort of manifest injustice? And is there any other middle ground here? Is there any other dry chemical that you could increase? Or anything short of a 180,000 gallon tank? 180,000 gallon tank is almost bigger than the tract that they are trying to occupy. And at the end of the day, I think, haven't been here on something quite like this, but I would think that this appeal, technically they're doing this, but it's almost a bit premature, because Judge Briley remanded this back for a further hearing consistent with his order, for them to have certain considerations and make findings of fact on the record that they were considering the appropriate things. And everyone knows that the government can meet with these little boards, these mayoral boards that are appointed, and sit down and say, look, these are the factors you have to consider, and you can still deny it. You just got to look at this and have the discussion and say the right things. All that we're here on is just to get a fair shake, to get that hearing where the factors are being considered appropriately and in conjunction with Metro Code 2.80.080.
If this matter is remanded to the board, is the board required to make findings of fact?
Judge, I don't think the board is required to make findings of fact, but I do believe that they are required to have, you see this all the time in the state when you're, the Division of Water Resources and all these other issues. You have to have the appropriate discussions and considerations in these inferior boards, so that'll be held up on appeal under the Administrative Procedures Act, or whatever procedural vehicle they use to have these board rulings reviewed. But in this case, it's certainly arbitrary and capricious, because the consideration is we're setting a precedent for neighbors, and the property doesn't seem like it's ready to be developed.
Yeah, I mean, some of this strikes me as sort of a buyer beware type situation, though. I mean, surely your client knew going in that this was in the urban services district, and there were certain promises that come with that in the Metro Charter, but you knew on the outset that those promises were not going to be fulfilled here. For example, water is not supplied there. They had to dig a well. So, I mean, yes, it's supposed to be an urban service district, but clearly Metro is not supplying all the what was promised for urban service district property. So, I don't know if that's a question or just a comment.
You can turn it into a question.
So what about that?
Do you want to respond?
So, Judge, there is a sense of, I hear what you're saying about, the buyer beware, and, that there wasn't water at the property at that time. But when you go to Metro as an applicant and you get an approved site plan and you get everything, you're paying you're paying $10, $12, $8,000 in for cutting trees to the tree bank. You're doing everything right. You're getting these approvals for wells and all of this. Then at the very end, the fire marshal says it's going to cost you $300,000 plus to run this fire hydrant, and you're thinking, well, this is the only tract in the urban services district on this side of Briley Parkway. It's a really weird perfect storm scenario. Because if you were in the general services, you're paying 0.4 less, and you don't expect that you're going to get the increased fire protection.
And does the 2012 fire code provide, extend to general services district properties?
Yes, I believe it does, Judge. That
Okay.
is our 2012, that's our 2012 fire code. I believe that it would, and under the government's laws in which they operate. But again, that in and of itself is why that board is there. It doesn't make a difference where you're building, and it doesn't make a difference if it was a 500 square foot building. It still has to have the minimum amount, which is 1,500 gallons per minute flow rate for a 2-hour period of time. And again, they have done everything they can. They've tried to enter a participation agreement with Metro saying, we'll meet you halfway. But at the end of the day, this is almost like an inverse condemnation we're taking because the property's worthless. It's industrially zoned land, which we have hardly none remaining in Davidson County.
Yeah, of course, the fire code serves not just to protect the property owners and the property, but the firefighters as well, of course. And so, I mean, we don't want to put firefighters in a situation where they could be injured or hurt trying to fight a fire because they're required to do so under the Metro Code.
And there was discussion about that, Judge McBrayer. There was a lot of discussion about, in the record, well, if this is if it's a paint fire, there's some kind of fire with gasoline, do you put water on that? Right? No, I mean, I think the dry chemical process is probably more favorable for anything that involves a petroleum fire because we all know what happens when you put, water on top of a gas fire. Moreover, it was important to point out no one is spending the night in this building at all, okay? And there's several other tracks around that particular area that are probably going to end up being developed. And all the while this was going on, the Bordeaux landfill catches fire, and there's no fire hydrants around. So this is something that really would benefit everyone in that particular area, but that cost should not be borne by the applicant at such a high rate when you are in the urban services district. That is the Metro charter. The Metro shall provide. If you look at the difference in the urban services and general services district, it says shall provide increased water, access to water, shall provide increased fire protection. That is why you're paying the higher tax rate. You got a minute left if you have any questions.
Hearing none.
All right.
Right.
And I would just submit to Your Honor that the ruling by Judge Briley that it was an arbitrary and capricious decision is the correct ruling, and we would ask for you to affirm Judge Briley's ruling. Thank you very much.
Thank you, Mr. Leonardo. Ms. Hadaway?
All right, so first of all, the appellee's arguments concerning the charter are not permitted to be heard here today. A writ of cert is an appellate review, while a declaratory judgment action, which is what their charter argument falls under, and what actually is existing and still pending in circuit court. A deck action invokes the court's original jurisdiction, so consideration of both of them together is inimical to a proper review. Like oil and water, the two will not mix, and that's Goodwin versus Metro Board of Health. So you can't also opt for a well and then complain you don't have water service. That was a choice. The appellees chose to have a well on the service rather than extending the water main for regular water service. The fact that they didn't understand that would mean they couldn't hook up a fire hydrant at that point, that is, as you're correct, a buyer beware situation.
Yeah, I was about to ask, is this a buyer beware? And they should have investigated these things before they spent a whole bunch of money.
Absolutely, they didn't do their due diligence. This is a situation in which we have this, they want to call themselves a mom and pop situation, but this is an LLC. These people are sophisticated consumers, and you're expected to take the time to do the due diligence, and not just put it back on the city to pick up where you didn't do your due diligence. The fire flow rate, by the way, is also not the same for buildings from 0 to 12,900 square feet. That is, again, as noted on page 10 of Metro's reply brief, a misreading of the chart. It's actually 0 to 5,900 square feet, which Pelly's are there at the top at 5,000 square feet. Concerning comments about what would happen if other people could do the same thing that the board made, or if they said that it's not able to be developed at this time, those are comments concerning the public interest. They're under 2.80.080, prong number 2. They're allowed to consider what would happen with the public interest if they make these decisions. Again, the only hardship appellees have articulated here is pecuniary harm. And your honors cannot allow pecuniary harm, and have not allowed pecuniary harm by itself to be the sole reason for granting a variance. And in closing, your honor, we ask that your honors reverse the decision of the trial court and affirm the decision of the board. Thank you very much.
But before you close,
Sure.
are we presuming that the board's decision would be the same if it considered the relevant factors? Because here, I think the record indicates that they did not consider the factors that they were to do. But what I hear you saying is that the end result is going to be the same, and maybe I'm misunderstanding you, but I'm of the impression that we may still have to require the board to do its job, even if it winds up with the same decision.
It is, again, Metro's position that the board has done its job, and I can't forecast how they will do their job a second time. We're solely deciding on what we have in front of us right now.
All right, thank you very much.
Thank
Thank you
you.
both for your arguments. Call the next case, please.
Heritage Construction Group LLC versus Karen Vest.